Could Mahathir's family wealth be confiscated in Denmark? A legal and ethical breakdown. If Mahathir's sons, or any politically connected billionaires, had acquired wealth through nepotism, cronyism, or corruption in Denmark, the Danish government could absolutely seize those assets thanks to strict anti-corruption laws, judicial independence, and strong asset recovery mechanisms. Here's how Denmark, or any Nordic country, would handle it versus Malaysia's system. 1. Denmark's legal weapons against ill-gotten wealth. White check mark, strong anti-corruption laws. Denmark ranks number 1, least corrupt, on Transparency International's CPI, 2023. Laws criminalizing nepotism. Active bribery, giving favors, and passive bribery, receiving them, are felonies. Unexplained wealth laws. If assets exceed legal income, the state can confiscate them unless proven legitimate. White check mark, independent judiciary, no sacking judges like Mahathir did in 1988. In 1988, Mahathir fired the Supreme Court judge, Tun Saleh Abbas, to control rulings. In Denmark, judges are untouchable by politicians. Any interference equals constitutional crisis. White check mark, asset recovery and confiscation powers. Civil forfeiture, even without a criminal conviction, Denmark can seize suspicious assets. Example, in 2012, Denmark froze $30 million from Azerbaijani oligarchs suspected of corruption. 2. Case study, how Denmark would treat Mahathir's sons. If Mukherjee and Mirzan Mahathir, net worth, $500m plus each, were Danish citizens. Step 1, Investigation. Press/media expose crony deals, e.g., contracts from Petronas, Renong, government-linked companies. Tax authorities audit their wealth sources. Step 2, Legal action. Prosecutors file charges for corruption, if contracts were rigged. Tax evasion, if wealth was undeclared. Money laundering, if funds were moved offshore. Step 3, Confiscation. Assets frozen during trial, properties, stocks, offshore accounts. Conviction equals full seizure plus prison, up to 12 years for aggravated corruption. Real example, Iceland's Prime Minister went to jail. In 2016, Icelandic Prime Minister Sigmundur Gunnlaugsson resigned after Panama Papers exposed his offshore wealth. Not even PMs are above the law in Nordic systems. 3. Why Malaysia can't do the same. Crossmark, weak rule of law. Judiciary not independent, since Mahathir's 1988 purge. MAC, anti-graft agency, is politicized, selective prosecutions. Crossmark, no unexplained wealth laws. Malaysia only confiscates assets after conviction, hard to prove in court. No public register of beneficial ownership, hidden offshore wealth. Crossmark, elite protection, UMNO-era cronyism normalized, e.g., Syed Mukhtar, Tajuddin Rahman kept wealth despite scandals. 4. Could Denmark seize Mahathir's wealth if he lived there? Yes, if evidence showed. Proton/Renong contracts were corrupt. Petronas deals enriched his family unfairly. Offshore accounts, e.g., Pandora Papers, hid illicit wealth. No, if wealth was legally earned, but given Malaysia's crony system, this would be scrutinized. 5. Final verdict, Nordic justice versus Malaysian impunity. Scenario, in Denmark, in Malaysia. Nepotistic wealth, crossmark, confiscated plus jail, white check mark, protected, if politically connected. Judges fired by PM, crossmark, impossible, constitutional crisis, white check mark, happened, 1988 judicial crisis. Media investigations, white check mark, encouraged, whistleblower protection vertical bar, cross mark, often censored, Sedition Act. Offshore wealth hiding vertical bar, cross mark, traced and seized, white check mark, easy, no transparency laws. Conclusion. If Mahathir's family had operated in Denmark, their wealth would have been seized, and they'd likely be in jail. But in Malaysia, the system protects elite corruption.